In comparing the ADEA to Title VII, the ADEA is much more lenient than is Title VII regarding, what is considered to be an adverse employment decision. The ADEA actually allows an employer to rebut a prima facie case of age discrimination through what we call a reasonable factor other than age that motivated the decision. Now, obviously, that means it's reasonable factor means we're not going to discriminate based on other characteristics, right? We're not going to say, oh, well, it's because she was a woman, because that would be illegal. But there may be other reasons and a reasonable factor, like performance, like skill set, what have you, that may be considered reasonable other than age that motivated the decision. And so that reasonable factor other than age is the big issue about how do we determine what is considered reasonable beyond age. And age may correlate with it, but if the performance is shrinking, if performance is not happening, then you can say that's a reasonable factor other than age. It may be correlated, but it doesn't mean that that is the decision that wasn't necessarily made based on age. A claimant is not barred because a favored employee is also greater than 40. So someone can say a 55-year-old can be discriminated against based on age against a 45-year-old. Now, it might be different if it's like 55 and 54, right? There's no real meaningful difference there. But we can have a difference between 45 and 40, 55 and 40, or 55 and 35, right? There is no reverse discrimination claims available to protect younger workers. There are some at some state levels, right? But not for age discrimination under the federal laws. There are some states that have what they call sovereign immunity, which basically insulates them from age discrimination claims by state employees. And I believe the textbook has a list of those states and who is protected under that. They have very specific record-keeping provisions for employers to ensure appropriate and adequate information exists to age-related hiring practices. So we want to make sure the types of record keeping that we are doing is very specific for ADEA. So you need to be aware of that relative to Title VII. So there may be an additional layer of documentation and record keeping that we need to do given the ADEA requirements versus Title VII requirements. State laws really vary widely on ADEA or age discrimination. In fact, Alabama and Mississippi have no age discrimination laws on the books, which means they are held to standards at the federal level and only at the federal level. Other states have laws that protect against age discrimination, and the textbook does a really good job of a very good detailed list of each state and where their protections are and where their limits are. So we want to make sure we keep track of where we're at and how those protections may change or adapt. There are some that go as low as 18 and as high as, and some of it limited at 70 and some of it goes higher. So we could actually make claims under state discrimination if we feel like we've missed the window of opportunity to make claims under federal. So anybody who's been a victim of age discrimination needs to decide whether it makes sense to file claims under state law or federal law in those respects. But both work simultaneously. Greater protection may happen for smaller employers. So state age discrimination has sometimes their minimum standards are in terms of the number of employees you have to have is significantly less, or there are no limits, as compared to the federal statute, which is 15. State age discrimination, as I said already, offers a wider range of damages and had longer filing periods. And so you might miss your window under the federal law, but their state law may have longer. No state is permitted to extend the protection to someone younger than 40, although there are some states that will allow claims to come forward, but I'm not sure how successful they have been. So even though they're not permitted, I know that there are states that have had that set up. So for the employee, they have to make a couple of decisions in order to be able to file. They may file a complaint using the internal grievance procedure. And there are other concurrent legal options, right? You can file with the EEOC, depending on the extent of the claim. File a complaint with the state equivalent of the EEOC. File a suit under the ADEA with a right to sue and under federal courts, or file a lawsuit in state court. So these are the different options, and you can certainly file in all four if you choose to. There's no limit. So you can do the EEOC, you can do the state equivalent of the EEOC, you can file in courts as well, all simultaneously. I always feel like, for me, personally, if I were filing a claim, I would start with the EEOC. I would start with their assessment, have an attorney on, and then between the EEOC ruling and my attorney, make a decision about where I would want to apply. And so employers need to be aware too, right, that if someone is going to come at you with multiple guns in multiple directions, whether it's the EEOC, the state level, and courts, you have to be prepared for this and know that there's a wider range of options in which someone can come after you for age discrimination. Under the EEOC, you have 180 days from when the discrimination occurs. It has extended to 300 days if the state has age discrimination laws and an administrative agency oversees those specific complaints. And so, again, knowing that, 180 days, if you divide 180 by 30, right, that's 6 months. You have 6 months to file a complaint for age discrimination, and 300 days, which is almost a year. It's probably 10 months, if I do the math correctly in my head. And that is and that's at the state level to be able to do that. So if it's after 6 months and before 10 months, then you can go through the state outlets for you. Upon receiving complaint, then the EEOC can dismiss it if they don't think there's any merit, or they can investigate, and then they can issue a right to sue letter. Both disparate treatment and disparate impact claims are available under the ADEA, but in order for us to make our prima facie case, there's obviously a number of elements that go into play that parallel but do not specifically are identical to Title VII, as we've already talked about. You need 4 elements to pursue your claim. Number 1, you have to be a member of that protected class, which means you have to be 40 or older. That's the first one required. There has to have been some sort of adverse employment action, a termination, a demotion, etc. You have to be qualified for the job, which means that you are able to meet all the legitimate requirements, and typically have been doing the job successfully. Dissimilar treatment versus non-protected or younger employees based on age. Note, treating people dissimilarly is very, there has to be some sort of different treatment, like being older, you're being treated differently than somebody who's younger or who's non-protected based on age. So the comparison is, how am I being treated? How are they being treated? Is there a differential treatment because of age? The micro-targeting of ads, as we talked about, is a specific issue where older workers are being excluded from the applicant pool. They were not being targeted, and that younger workers were being targeted for those ads. So that's an example of a dissimilar treatment in those circumstances. The Gross case in 2009 sort of talked about burden shifting, where the burden of proof falls. And so we're going to start with talking about the way it was before the Gross case, right? Once a prima facie case is presented, the burden of proof does shift to the employer to present a legitimate, non-discriminatory reason for its actions, basically saying, I'm not discriminating and here's why. In mixed motive cases, discrimination may be found to be a sufficient motivating factor, even in the presence of a legitimate non-discriminatory reason. Discrimination can be among the reasons for the employer's action. And so what this means with a mixed motive case, right, that you can have some legitimate reasons, an LNDR, if you will. The LNDR reasons are fine if that was on its face value, that was all there was, the person could legitimately have the action placed against them. But once you get language in there that discriminates, and it is discriminatory, that's when age can be considered a motivating factor in that particular situation. age discrimination cases under the ADEA require proof that the age was the but-for cause of the adverse employment action. So it is important that, but for their age, even though there may be a mixed motive, if age it was included in this, but for the age, and there is an adverse action, then that's considered the uh, criteria needed for age discrimination, the but for. So recall this as you're reviewing your cases, making sure you're clear on, you know, what sort of information is needed there, right? Unfortunately, the Gross case, which is Gross versus FBL Financial Services, shifted things. And now there is no longer the burden shifting. It doesn't shift. The plaintiff has to prove that age was the but-for factor. Mixed motive cases do not exist under the ADA in disparate treatment. So it might have been like that previously, but it has really evolved and has changed given that. And we're still waiting to see how other courts are going to be dealing with this particular case. Um, it's still important for us to investigate and to understand the application of gross. We're hoping that there may be some adaptations and shifts in the way it's interpreted, but it's hard to know. An employee could recover only if the employment action would have not have taken place but for the age discrimination. So that but for case is the only proof that the employee needs to make, and it's hard. It is hard to make. Age not need to be the only factor, but a primary factor, right? Gross has been difficult to apply, right? I mean, it's been the biggest problem is how do we apply this, and it hasn't been applied consistently. But the courts of appeals have basically said that age doesn't have to be the only factor, right? A primary factor, but not the only factor. The burden of producing evidence has shifted to the claimant, who has always borne the burden of persuasion in all discrimination cases. So the producing the evidence really has to come from the claimant in this situation. And public sector cases, the mixed motive does still apply. So in private, no, but in public sector, working for state and local and federal government agencies, you can still use mixed motive as a standard. An employer can say that there is a bona fide occupational qualification for age. Age is one of the most consistently applied BFOQs. And so the EOC has provided some really clear guidelines on how we can use it for ADEA cases. An age limit has to be reasonably necessary and to the essence of the employer's business. All or substantially all of the individuals over that age are unable to perform those jobs adequately. And some individuals over the age possess a disqualifying trait that cannot be ascertained except by reference to age, for example. For competent expert evidence or perception is not adequate. So you have to have a competent expert give you an opinion that anybody over a particular age with a particular trait cannot have that job. And so airlines issues are a big part of that, right? So can we allow older pilots to fly airplanes? Well, there's a public health issue, a public safety issue here. And so we are sort of addressing that. So that's why there are mandatory retirement ages for some positions, right? We can have a BFOQ that says you're over a certain age. We know that your response time and your reaction times are going to be decrease, and therefore we will not allow you to continue to fly or serve as a police officer or whatever that might be. You can do individualized health assessments to some extent. So we just need to be really careful about how we manage that. The EEOC requires individual assessments when it comes to pandemic response, right? So we can say we don't want somebody to have, they perhaps based on the pandemic or whatever, we may not want somebody doing a particular job. So we just have to keep that in mind. Employers may also observe terms of bona fide seniority systems, voluntary retirement plans, and discipline employees for good cause. So it is, some things are still available to us, right? A bona fide seniority system can have the oldest worker in your organization. We still have to adhere to the bona fide seniority system in terms of layoffs and, last in, first out kind of thing. Voluntary retirement plans. We can't force somebody into retirement, and we can discipline somebody if they're not doing their job well. Period.